A tort is a private wrong in which a person or property is harmed because of another's failure to carry out a legal duty. That's what a tort is. So a tort is, and just like we learned in chapter 3 when we classified law, if we're classifying it as civil, we know that it is a harm against a person or perhaps a corporation, but it is not against the society. So when we look at a case and it may be Grimes versus Grimes or Grimes versus the company, there is an individual wrong. I have been wronged by this company, but it is not a lawsuit on behalf of society, which is what criminal is. So when we refer to torts, we have intentional torts, negligence, and strict liability. So I'm going to begin with intentional torts. Intentional tort occurs when someone intends an action. They intend to do it. So it includes malice. That's what malice is. That is the malicious intent to commit or to harm someone, their body, reputation, emotional well-being. So body, reputation, emotional well-being all depend on what type of tort we're talking about, what type of intentional tort we're talking about. So under intentional tort, someone intends an action that results in harm to a person. So when we're looking at the underlying elements, there has to be intent. Did the person mean to commit the harm that resulted? If they did, then we may have an intentional tort. The first intentional tort, assault. Now, oftentimes we think about assault and battery as they go hand in hand. And on the criminal side, assault does include battery, depending on the charge, and the statute breaks down between 1, 2, and 3, assault and battery, or just battery. But on the civil side, assault and battery are two separate torts. The assault is the intentional act that creates the reasonable fear that one will suffer harmful or offensive conduct. So that's the threat. The assault is the threat. The battery is the intentional act, the harmful or offensive, unwanted contact, excuse me. So assault and battery can go together. You can have an assault and a battery, or you can just have an assault without a battery. That means that the person felt threatened, but there wasn't the actual contact. Or you can have the battery without an assault, which means that the person didn't see the harm coming, so they had no fear, but then the person touched them or punched them or somehow harmed them. So at that particular point, they've been subjected to the battery, but not the assault. So while assault and battery can go hand in hand, they can be separate on the civil side in terms of what claims we would file. So you can file an assault claim or you can file a battery claim. But again, they do not necessarily have to go hand in hand. Now keep in mind, battery is an intentional act that creates a harmful or offensive physical contact. So can a kiss be a battery? The answer is yes. If it is harmful, if it is unwanted, then it can be a battery. It doesn't necessarily have to be someone punched you in the face. It is an unwanted contact. And that contact also includes anything that is attached to the person. So if I'm working in a restaurant and there's a customer who continues to send something back and I then get agitated and I grab the plate from the customer, that plate is an extension of the customer. So the courts have viewed that as a battery. I snatched it, and because it's a part of her, it was an unwanted, harmful, offensive physical contact. Um, Now, whenever we talk about battery, we also think about it in terms of transferred intent. So if you punch someone and you reach back and throw the punch, but you miss that person and hit someone else, you can't then say, I didn't intend to hit that other person because we interject transferred intent. It's a legal term, and if a harm is directed to one but harms another, the intent with the punch, the intent travels with the punch, will be transferred to the other person. So I meant to hit A, but instead I hit B by accident. So if I hit B by accident, by definition, that does not satisfy battery because it wasn't an intentional act, but the courts will follow the initial punch, which was to A, and look at my intent at that point. And so because the intent was to hit A, that intent will then transfer to B. It's called transferred intent. Now in your book, there's the Knight versus Jewett case, where you have two parties who are playing touch football. Again, it's supposed to be a friendly game, and touch football is just that. You touch. You don't tackle. you touch, that means that the play is supposed to end. But you have Mr. Knight, I'm sorry, Mr. Jewett, who is very aggressive in the game. And he steps on Knight's finger. And at that particular point, she's injured and she sues for battery. So it's an unwanted touching, okay? And it's intentional. So did he intentionally step on her finger? So the court said even though she was injured, she would need to demonstrate his intent to commit the act of stepping on her finger. Now, despite the fact that he's been very aggressive throughout this game and throwing people down and just playing extremely out of context for a touch football, friendly game of football, the court said at the moment that he stepped on her finger, he did not have the intentional act to create that harm. Because prior to that, the reason why she was on the ground is because he was being aggressive. But when he got up and he was running for another play, he accidentally stepped on her finger. So, based on her own account, she did not believe he intended to hurt her finger. He intended to throw her down on the ground. So if she would have broken her finger because he was being very aggressive in the game, then that would have been the battery. But because he accidentally stepped on her finger, that right there does not constitute the battery. Now, there are defenses to assault and battery. A defense is just that. If these claims come about, then you argue this as a defense. It doesn't mean that you win, it just means that you have a defense. So one defense is consent. So going back to my question about battery being an unwanted kiss, if someone asked for it and I gave it to them, meaning the kiss, then that would be consent. So you can't now argue that it was battery because you consented to the kissing. Self-defense, defense of others, and sometimes defense of property can be argued in terms of assault and battery. But you are never to use deadly force when protecting property. And when we talk about a defense, you must only use as much force as is necessary to stop the battery. So if a person is punching, you can't bring a knife to a fist fight, is how it goes. So we want to have pretty much as much force as is necessary to stop the battery. So if the person is punching you and you're able to stop them with a punch, then that's where we have to stop. Some people get in trouble because they just take it too far. At that particular point, if the person is stopped, then you stop. You can't keep beating them to teach them a lesson, although they were the initial aggressor. False imprisonment. Okay, through force or the threat of force, you unlawfully detain another person against his or her will, and there's no exit plan. There is no means of escape. Okay, so if there's a door and I say, you better not leave here, that doesn't necessarily constitute false imprisonment because you had the ability to leave. But if there's the force or threat of force and the person doesn't leave because that force is extremely great and they are afraid for their safety, then yes. So the court has held that if there is a means of escape, it does not necessarily preclude a false imprisonment, but false imprisonment by definition is an intentional act that caused confinement without or restraint without a means of escape through force or the threat of force. Now, defamation. Defamation is the publication of a false statement that causes harm to a person's reputation. There is a difference between me giving my opinion and stating something as if it is a fact. So if I say my lawyer is lousy, that's not defamation. That is my opinion. You can give an opinion, but if I say my lawyer is lousy because my lawyer didn't file documents and I gave a list of things that now takes my opinion into a factual situation, then we've crossed into defamation. Now, defamation is slander and libel, S for spoken, spoken slander, S and S. Libel is written defamation. So what it means is that someone writes it down, that's libel. If someone speaks false statements, that's slander. They all fall under the umbrella of defamation. Now, there must be something of value. The harm must be something of value. So for an example, you lost a job, you lost an endorsement deal, that's going to be your defamation. So just simply publication of false statements in and of itself is not going to be defamation. We have to demonstrate the harm because the harm is where we estimate damages. So the court is not a place where we go for hurt feelings. We are asking, as a litigator, I am asking for damages and I have to be able to calculate that. So the damage to my reputation is I lost a contract, I lost a job, I lost an endorsement deal. They are valued at this particular amount of money. Now, in addition to the defamation, now, defamation is publication of false statements. Can you publicize statements that are true but highly sensitive, okay, or embarrassing facts? So if the statement is false, we're in defamation. If the statement is true, we may be under invasion of privacy. Invasion of privacy includes disclosure, intrusion, appropriation, and false light. Disclosure is publicizing embarrassing or private facts. So, if it is publicized, if the matter publicized is of a kind which would be highly offensive to a reasonable person and there isn't a legitimate public concern, then we may have an invasion of privacy disclosure issue. Okay, so for an example, if you owe the college money, let's say there's a debt, if they put everyone's name up on the wall and there was a weeping window wall where everyone who owed a debt, then that right there may, while it's true you owe this debt, it is your private business. So therefore, you are now in invasion of privacy disclosure. Okay, invasion of privacy intrusion is an unjustified intrusion in another's private activities. Okay, then at that particular point, an example is eavesdropping. So a landlord bugs the tenant's bedroom. Okay, we just had at Rams Head not too long ago where they were putting cameras in the toilets to observe women in the restroom. That is an intrusion in your private activity. You are in a bathroom. What you do in there, you plan for that to be private. Okay? Appropriation is the unauthorized use of one's personality, their name, or their picture. So if you have a jersey and and you are somehow insinuating that a Baltimore Raven, although you haven't compensated them, patronizes your establishment. And in your commercial, while you don't show a face, you show the jersey with their number on the back, and it kind of insinuates that this particular Raven really loves your establishment, then that is an appropriation because you're using that person. It's not authorized. You haven't paid them for it, and you're using their likeness for your benefit, because why else would you put them in your commercial? You want people to come and patronize your business as well. So that is for the benefit of you, so therefore appropriation. So when you have a celebrity endorsement of a product, most likely the celebrities are being paid for that unless they decide that they want to do it for free. False light is the use of a picture or other means to infer a connection between the person and an idea or statement for which the individual is not responsible. So, for an example, you are falsely stating that children are living in poverty or a family is homeless because around Thanksgiving you're handing out flyers, which again is a very benevolent gesture, but you put this family on the flyer and it would insinuate that this particular family is homeless and or living in poverty, which is not their particular status. So that right there would be false light. Now, looking at these intentional torts, there's also a intentional torts that deal with property, trespass to land, when someone invades your rights to your property. So you can have, when we talk about trespass to land, that's not just for you physically trespassing to land. It is also anything that you allow to trespass the land. So fireworks, if fireworks go up, they leave acid and not acid, ashes and soot. So if my neighbor constantly has a fireworks display and then they come down, at that particular point, they are coming down in my property, maybe a trespass to land. Trespass to personal property is an invasion of your rights. It is an interference with your right to enjoy. So an example would be if I have a barking dog and my neighbor comes over and they don't want my dog, but they want my dog to shut up, so they let my dog loose. That is a trespass to my personal property. A conversion, which is also the civil side of theft, is the intent to you take away and to permanently deprive. So they then take my dog home because they never want me to see it. The trespass to personal property is an interference. It means that I can't have access to my dog right now, but maybe Fido comes back home. So it wasn't the intent to permanently deprive, although it may lead to that, and then we may be in conversion. So you can have a trespass to personal property, which may also be a conversion, but it doesn't necessarily have to be a conversion because, using my example, if my dog returns There wasn't the intent to permanently deprive when they let the dog loose, and that's what they would argue.